Garden State GSCLE. 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 Garden State GSCLE.
We're going to be looking at provisions of the New Jersey Code of Criminal Justice, Title 2C, general provisions, some of the statutes, and then we'll try to discuss each one of them, but in the context of movies. So what we're going to do is we'll show a movie clip, and we'll assume that everything in the movie happens in New Jersey, then we'll talk about the concepts of it. I want to start off discussing the code kind of generally. The code went into effect on September the 1st of 1979. It was really the legislature's attempt to modernize New Jersey criminal law and conform it to the general precepts of the model penal code that was being developed at that particular time. So in many respects, our code follows most of the model penal code. Some of the statutes that were set forth in the code were adopted, some were modified, some were rejected at the last minute. We'll talk about them as we go forward. One of the things that the code, though, intended to do was to abolish any common law crimes that were on the books. And I wanted to kind of demonstrate this because it's important for us as practitioners today to kind of think about this. And you know, there's not a whole lot of movies they make about abolishing common law crimes. Did you guys ever notice that? It's just not a hot topic in Hollywood. And then I remembered something from 1978. Do you realize that Bob Rosenberg was actually 47 years old then? I mean, this is a long time ago. Take a look at this, see if you guys remember this. This is 1978, all right? Talking about common law crimes. See if you guys remember that.
Send in the accused! The case of John the Tanner versus Lord Colchester.
John the Tanner, you have stood twice before this court. First, you were found guilty of theft, and your right arm was cut off. Then you were found guilty of lying, and your tongue was carved out. Now, you stand charged again. How do you plead? I see. And of what is this man accused?
Adultery, Justiciar.
Let's see, adultery. You were found guilty of theft, and your right arm was cut off. You were found guilty of lying, and your tongue was cut out. Now, adultery. The writ of common wisdom.
The writ of common wisdom.
The punishment for adultery is... Oh, I can't read this publicly.
Here she was accused of consorting with the devil.
Congratulations. She was found innocent.
Oh, thank God. Where is she?
At the bottom of the trough of justice. You see, if the body is accepted by the water, that means she's not guilty.
She's dead!
Well, she must have drowned from being under the water.
You call this justice, an innocent girl dead?
Yeah. Hey, God's will.
Why don't you just admit it? You don't know what you're doing. And who are you to interpret God's will?
Yeah, by what right?
Well, the king. It's the law.
Well, the law is wrong. The law should be changed.
You know, there is a point in what she is saying there, I think.
Wait a minute. Perhaps she's right. Maybe the king doesn't have a monopoly on truth. Maybe every man should be judged by his peers. A jury of his peers. 6 good men. No, wait. 8 good men. No, 10 good men. No, that's not enough. Let's see. 18 good men. No, that's too many. Let's see. 11 good men. Wait. 13 good men. No, 11 or 13, it really doesn't matter. Okay. But every man should be tried by a jury of his peers and be equal before the law. And perhaps every man should be free from cruel and unusual punishment. Nah.
This entire court stands adjourned.
This is the statute. Common law crimes are abolished, and no conduct constitutes an offense unless the offense is defined by this code or another statute of the state. Several things that kind of flow from this. Number one, it's just amazing to think back as recently as 1979, which to me is like 3 weeks ago. That we had all these crazy common law crimes in the books that people could get prosecuted for. In fact, there were people like being prosecuted and being convicted of adultery and things of that nature back in that era. I'll tell you something funny. There's one common law crime that still kind of resonates today. There's a list of statutes that are ineligible for expungement, and one of them is the common law crime of embracery. Anybody know what embracery is, by the way? It has nothing to do with kissing. Apparently, it's utilizing trickery and deceit and things like that to influence a jury in an improper way, embracery. And in the expungement statute, they actually have that listed as one of the common law offenses that you're not allowed to expunge for some crazy reason. So the bottom line on all this, what the takeaway from it is that nothing is against the law in New Jersey unless there's a statute that makes it against the law, all right? The only vestige of a common law crime we really have left in our state at this point is contempt of court, although apart from being a common law offense, it's also statutory, it's in the court rules. So, I mean, it's just an essential function of the court, and that's why they've maintained it to that extent. Now, just because common law crimes have been abolished in New Jersey, that's fine, but the legislature didn't do anything to abolish common law defenses. So all the common law defenses that existed for centuries, they still exist in New Jersey today and can be extremely useful. You stop to think about the code defenses, they're really just a product in most instances of common law defenses. So as a defendant in a criminal case, you have your choice of selecting either a common law defense or a code defense to the extent that they parallel each other. Sometimes there's some additions in the code defenses that make it a little bit easier. Where this is of particular importance, though, is in traffic offenses, because once in a while you'll come up with a common law defense to a traffic offense. You can utilize a common law defense when defending a traffic case. You're not permitted to utilize a code defense in a traffic case, like drunk driving, for example. The case standing for this is an old Supreme Court case from 1990 called State versus Hammond, where the defendant tried to use entrapment or something of that nature as a defense, but he tried it as a code defense. Subsequent cases before the Supreme Court have allowed, though, the use of all manner of criminal code defenses, typically in defense of drunk driving. I think the most important case dealing with this, it's the name that escapes me for a second, it'll come to me in a minute, but the guy used the defense of necessity. Oh, I know what it was. State versus Romano is the name of the case. It's a different Romano. It's not Romano versus Kimmelman, it's a different Romano. He utilized the defense of necessity in a drunk driving case where he was being beaten upon by some people in a parking lot of a restaurant. He got into his vehicle and drove away to escape being killed, literally. Was stopped by the police, found to be intoxicated, but was able to successfully argue under common law necessity that he had to get out of there to save his own life, and he was able to do so successfully. So the vestiges of this is no more common law crimes. Remember, embracery if you're going to be doing an expungement. Common law defense is not affected by this at all. Nothing is against the law in New Jersey unless there's a statute that makes it against the law. Now, I want to get into the culpability states a little bit for a second. There are officially 4 culpability states. People can act either purposely, knowingly, recklessly, or negligently. There's a 5th one that I want you to keep in mind, which is basically no culpability state, strict liability offenses. And we'll talk about that a little bit in a couple seconds, but in the context of the code, I don't know, what do you have? Strict liability for drug-induced death is one, felony murder is another. They're out there, and typically the legislature leaves no doubt when they want to have an offense be a strict liability offense. I want to start off by talking about purposeful conduct. And the little clip we're going to talk about really gives a kind of a good example of what constitutes purposeful conduct. Remember, when you're talking about these culpability states, these are elements of an offense that have to be proved beyond a reasonable doubt, like anything else. And so you can't look inside of a person's mind. So how do you prove these? What's the evidence used to prove these culpability states? And what are they going to be? Admissions, confessions, and circumstantial evidence, which lets you draw inferences as to what the guy's culpability state was. Let's talk about purposely and take a look at this movie real fast.
Now, me and Enriquez is in the service, too. There's nothing like old war buddies. Well, have a nice trip now. Take care. Oh, here. Have some beers in Valverde Matrix. It'll give everyone a little more time with your daughter.
You're a funny guy, Sully. I like you. That's why I'm going to kill you last. Move.
Sally.
Kiss my ass.
I can't hear you.
I'll say it a little louder than get fucked.
Listen, loyalty is very touching, but it is not the most important thing in your life right now. But what is important is gravity. I have to remind you, Sally, this is my weak arm.
You can't kill me, Matrix. You need me to find your daughter.
Where is she?
I don't know. But cook those. I'll take you where I'm supposed to meet her.
But you won't.
Why not?
Because I already know. Remember, Sally, when I promised to kill you last?
That's right, Matrix. You did.
I lied.
So here's the definition. Except as provided in subsection 3, person is not guilty unless he acted purposely, knowingly, recklessly, or negligently. All right? Here's the definition of purposeful. Person acts purposely with respect to the nature of his conduct or the result thereof, which is, in this case, is going to be homicide, if it is his conscious object to engage in that conduct of that nature or to cause such a result. So, do you think that Arnold Schwarzenegger was guilty of purposeful conduct? Was that his conscious object to bring about the death of this guy? What do you think? Just for bad acting, if nothing else. Can you imagine we elected this guy governor of California? I think twice, actually. So, but if you put it together, what was the evidence to suggest that he acted purposely? He had, he announced ahead of time that he was going to kill the guy. He told the guy that he lied. He was going to, he lied when he said he was going to kill him last. Everything about this would allow the fact finder to draw the inference that it was his conscious object to cause that result, specifically the death of this guy. Everybody cool with that? You're going to see how these concepts are going to come back and get a little bit more complicated as we go into some of these other clips. All right, that's purposeful. Let's take a look at knowing. And knowing actually is a little bit more important than purposeful for a lot of reasons we'll talk about momentarily. I had a real tough time as a younger lawyer trying to understand the difference between purposeful conduct and knowing conduct. It was very confusing for me as kind of a young guy. And it was important when we were talking about homicide cases when they had a death penalty, because in order to qualify for a death penalty, you'd have to commit a murder either purposely or knowingly. And I had a very difficult time conceptualizing the difference between the two of them. And then a case came out around 1990 called State versus Clausel, which involved some hitmen who came to a house. The victim saw them, slammed his door, and the hitman fired bullets through the door. And there's a wonderful discussion of the concept of knowing conduct as a culpability state by the Supreme Court in that case. And I thought to myself, what kind of case, what could I come up with a movie that would demonstrate that? Take a look at this, guys. 1949.
How you doing, Parker?
Stuffy in here. I need some air.
Oh, stuffy, huh? I'll give it a little air.
My cardiologist tried to teach me a lesson. He said, you see that scene that Jimmy Kennedy's eating fried chicken? He's eating that unhealthy fried chicken, and look at him now. Now he's dead. So he's trying to teach me to eat good, all right? Okay, here's the definition. Purpose acts knowingly with respect to the nature of his conduct or the intended circumstances if he's aware that his conduct is of that nature, or that such circumstances exist, or he's aware of a high probability of their existence. Here's the key in this little scene we saw. A person acts knowingly with respect to the result of his conduct, in this case, homicide, if he's aware that his conduct is practically certain, or it's practically certain that his conduct will cause such a result. So when you take your gun and you fire it through in that way blindly, it's certain or practically certain that you're going to bring about this particular result, okay, this homicide. Why I mention that knowing is so important is because knowing is the default culpability state under the code, meaning that if you're reading over a statute and they don't mention a code, they don't mention a culpability state, the legislature wants you to assume as the default position that the culpability state is knowing, all right? Unless the statute clearly evinces an intention by the legislature to have it be strict liability. Now, the reason I bring this up is because of the very hot topic these days, prosecutions under 2C40-26, the driving on the revoke list following drunk driving. And if you'll read the statute over, there is no culpability state set forth in the statute at all, and it does not appear to me in any way, shape, or form that the legislature intended to be strict liability. Normally, when they have a strict liability statute, there's no doubt in it. They use the word shall be strictly liable and things of that nature in the wording of the statute. None of that is there. So what you've got to be insisting of your defense attorney is that the state, both at the grand jury level as well as at trial, be able to demonstrate beyond a reasonable doubt the defendant acted knowingly. Knowing that he was driving, knowing he was on the revoke list, those types of things are arguments that you should be raising if you have one of these cases, okay? I suggest to everybody, until they kind of figure out what the jury charges are going to be and the case law gets a little bit better defined, is if you have a client who's been indicted for this, get a copy of the grand jury instructions that the assistant prosecutor gave to the grand jury and make sure that they discuss this particular element with the grand jurors, because if they didn't, it's going to give you some ammunition for, at a minimum, moving to dismiss the indictment for want of proper instructions to the grand jury, okay? At the trial level, you've got to insist that there be a charge to the jury on knowing. Everybody got that? Okay, keep that in the back of your mind, very important. All right. Now, next is reckless. And, you know, I want to talk about recklessness. I've got a couple of examples that I give with students sometimes. I want to take a look at this, and I want you guys to make a determination about whether you think this guy's conduct was reckless and whether he committed any type of offense at all, notwithstanding the recklessness, okay? Let's take a look at this and we'll discuss this. And, Tommy, I'm going to ask you to pay particular attention to this one, okay? This is right in your wheelhouse, so to speak.
America, to restore its future, to rise to our best ideals, and to elect Barack Obama President of the United States.
I'm afraid we're about to lose another Kennedy. God bless him. You want another?
No, I'm good. Rodney was supposed to meet me here a half hour ago.
Oh, yeah. How is old Rod? He seems awfully quiet last few times he was here.
Yeah. He stopped lost again. He's going back next month.
Oh, those poor sons of guns, they're holding them against their will. They're going to run them into the ground. They're not careful.
Getting me started. Well, if he turns up, you tell him I headed home to see Lena?
Sure.
All right.
Oh, I got this one.
All right, thanks, Dan. Is John in? I just need to bend his ear.
He had someone back there earlier, but I think they might be gone.
All right, if
Yeah.
Cubs lead the Pirates 10-1 here in the bottom of the sixth. Chavez off of first base. Lilly still looking strong on the mound. And Lilly delivers. Swinging, there's a drive. Deep
hear me? Help. Help. Help.
All right, so here's the definition. A person acts recklessly with respect to the substantial element of the offense when he consciously disregards the substantial and unjustifiable risk that the material element exists or will result from his conduct, in this case, homicide. The risk must be such a nature and degree that, considering the nature and the purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. So let's kind of analyze what we've got going here. And Tom, I'm going to give you like a couple of different fact scenarios tied to the BAC of this guy. All right. Let's start off with the proposition that he has a BAC of 0.14. All right. How would you handle this type of thing up at the prosecutor's office? Vehicular homicide? Yes. Okay. And you would say that the 0.14 would, that would be the evidence of the recklessness that you would utilize. That element would be supplied by the 0.14 BAC. Agree?
There wasn't speed and other things.
Okay. Supposing that we change the facts to BAC's 0.25, something like that. Do you have, based on that level of intoxication, a level of recklessness manifesting an extreme indifference to the value of human life? So you're talking now all of a sudden about aggravated manslaughter as opposed to vehicular homicide?
I don't think there was any particular cutoff number. It would depend on the other circumstances.
Got it. Okay. Well, the fact that you have two people dead here doesn't help. One of them being a kid also is, that's not that good. Anybody see any defenses here? What do you think, Bobby?
They backed that right in front of them.
Right. So the argument is supervening causation, or I guess, you know.
That the alcohol was not an element of the offense.
Right. In other words, you have a causation issue. Okay. He can be as drunk as he wants, and it doesn't really make any difference. I want to talk about this causation issue for a couple seconds and commend to you a case, I think we have the citation in your materials, called State versus Eldridge. All right. Eldridge, to the best of my recollection, is also a double homicide case. The girl was convicted, and she had asked at trial for a charge on supervening causation. Her side of the story was, I was driving, I crashed into a tree, killed two people, but she said the crash was not caused by my intoxication. Rather, one of the boys in the back was playing games and put his hands over her eyes, and that caused her to lose control of the vehicle. Now, whether that happened or not, that juries make those decisions all the time. But she wanted a charge on it, which was denied to her in Superior Court on the trial level. Appellate Division said no, she had enough. She had to be able to tell her side of the story, and that would have merited a charge on supervening causation. Okay, so the fact that somebody acts recklessly is fine, but you still have to tie. There has to be a causal relationship between the result and the culpability state. Everybody see that here? So it's kind of a strong argument. And again, it's a close case between this idea of just ordinary garden variety recklessness, as you see here, as opposed to this enhanced level of recklessness, you know, conduct manifesting an extreme indifference to the value of human life that you would need to support the more serious charges, aggravated manslaughter, aggravated assault, things of that nature. Everybody cool? Okay. I want to take a look for a second at negligence. Many people regard as one of the greatest scenes ever. Let's take a look. See if you recognize this.
Just got home from Illinois, locked the front door, oh boy. Got to sit down, take a rest on the porch. Imagination sets in, pretty soon I'm singing. Looking out my back door. Doing cartwheels, statues wearing high heels. Look at all the happy creatures dancing on the lawn. Dinosaur controller, listening to Buck Owens. Looking out my back door. Tambourines provided by magician. Looking out my back door.
So here's the definition. Person acts negligent with respect to a material element of the offense when he should be aware of a substantial and unjustifiable risk that the material element exists or will result from his conduct, in this case the crash. The risk must be of such a nature and degree that the actor's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known, involves a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. That is the classic definition of negligence, not only in the criminal context, but also in the civil context. So, I was in Bergen County teaching a course with a bunch of judges, and there's had to be 30 judges there. We showed this scene, and I asked the judges, well, you think this guy was acting, is he guilty of careless driving or reckless driving? And I think it was like 100% of the judges said reckless driving. Stay out of Bergen County, guys, okay? There are a bunch of meat eaters up there. I don't see it here. I mean, I think that he was acting carelessly. What do you guys think? Was he reckless or careless? Careless. Careless, see? Careless. I think that's the right. What do you think, Bobby? Reckless? What? Oh, my God, why? Well, yeah, and then, you wonder, the cops say in the report, the car smelled of marijuana, the guy had the strong odor alcohol beverage on his breath, Our clients make it so easy for the cops, don't they? They just make it simple. There's no right or wrong answer in these cases. These are jury questions. I was thinking about an example. Let's say it's snowing outside, okay, and you're a lazy guy like I am. And you come out in the morning and you don't want to clear off the snow. You just want to use solar power and and you say you can see good enough, right? Now the wipers do it. You use your windshield wiper cleaner. Let the defroster do it because you're lazy like I am. So I mean, you can have a little bit of snow on your window and be able to see perfectly fine. You really shouldn't do it that way, but you can see well enough. All right. And if you have an accident, you run over a little kid, it's careless, all right? You shouldn't have been doing it. You should have taken the time to wipe it off. But at some point, you're going to have enough snow on your window where you're going to cross over from being careless to being reckless. You know what I'm saying? It's a question of degree. How much snow did you have on there? At some point, everyone is going to say that you were acting recklessly. At some point on the other side of the scale, most people would say you acted carelessly. There's a big area in the middle. Another example would be a guy who's driving through a school zone, 25-mile-an-hour speed limit, there's kids present. He drops a cigarette on the floor, is not paying attention, reaches down to get the cigarette, and strikes a kid, okay? So, if he's going 25 miles an hour and he's just not paying attention, it's going to be carelessness. By the same token, if you start ratcheting up the speed, 35, 40, 50, 60, 70 miles an hour, at some point, there's a speed at which this guy's going to be traveling that every jury is going to come back and say he acted recklessly. Where is that? I don't know. Everybody's going to say he was reckless at 70 and at 25. No one's going to say it at 25 and at 25. But if you're talking about 30, 40, 50, at some point, most jurors are going to say that constitutes recklessness. Okay, that's the deviation from the standard of care becomes so great that it's no longer carelessness, it's recklessness. Everybody got that? This is the art of advocacy. I mean, this is advocates, as defense attorneys, this is what you've got to be talking about when you discuss these things with jurors. Now, I want to talk about negligence in the context of homicide for a second. In New Jersey, back in 1979, when the legislature was considering the homicide offense, initially they did have a homicide offense in the code which would have been supported by a culpability state of negligence. And at the last minute, it was pulled and has never been enacted in our state. So there is no offense under New Jersey law for negligent homicide. You want to say it another way, a little bit more sardonically, you can kill all the people you want in New Jersey as long as you do it, negligently. There's no limit, okay? It's sad, though, in a way, because when you're talking about negligence in the context of a homicide that occurs in the motor vehicle context, normally, if there's been any type of negligence, this is stuff that's handled in municipal court, which is the least friendly court for these types of things. The court don't have the facilities, the training, the sensitivity, or the statutory support to deal with these types of cases. So frequently you'll have a homicide. Prosecutor's office looks at it. There's just no evidence of recklessness at all. It's it's just straight out carelessness. The guy blew a stop sign or did something that caused the accident, and the sentencing judge is left with a fine of between $50 and $200 and or a jail sentence of up to 15 days, and that's it. And you'll have, I don't know if you guys have ever been involved with these are terrible cases to have to deal with, where you have shrieking, crying, grieving family members. Have you ever done one of these things? What's that? Oh, you've done these, so you know what I'm talking about. I mean, I don't want to put words in your mouth, but these are hard cases, wouldn't you agree? And how do you explain to these families that, you know, what he did doesn't violate the criminal law, and the legislature has just got this as the level of punishment? I'd like to commend to all of you, and we'll give you the cite on this in a moment, a Supreme Court case called State v. Palma, P-A-L-M-A. It's a fairly recent Supreme Court case dealing with sentencing on careless driving cases. And this particular one involved a homicide and a jail term that the judge imposed for the driver. And the argument is, why are you putting me in jail? It's carelessness, okay? There's nothing in the statute that makes homicide an aggravating factor when there's a careless driving case. So the Supreme Court has created a set of aggravating and mitigating factors that judges have to consider when sentencing in a careless driving case. Now, this is very important. These factors are called Moran factors. They come out of a case called State v. Moran, which initially dealt with license suspensions, okay? And the exercise of discretion of when a judge is going to suspend a license for a willful violation. For carelessness, you can't, by definition, it's not a willful violation. But the Supreme Court borrows in full the Moran factors and plops them down now in the context of jail terms in careless driving cases, okay? There's also an appellate division decision, also fairly recent, Carrero is the name of that case, where the appellate division did the same thing with respect to jail terms for being an unlicensed driver. Again, requiring judges to weigh and evaluate the Moran factors before putting somebody in jail. So you've got to look at these Moran factors as opposed to the aggravating and mitigating factors in the Code of Criminal Justice, which have now been rejected completely by the Supreme Court, in terms of deciding how somebody's going to be sentenced in a traffic case, okay? That's all coming out of this Palma case. Everybody got that? Very important. All right, let's move on and take a look at possession as an act, all right? But there's something else going on in this little clip we're going to take a look at. It's a Fourth Amendment issue. This is the best example I could ever find of the plain view exception to the warrant requirement, okay? Let's take a look.
Fucking believe this. Look, God damn it, I knew it. I fucking knew it. Oh, fuck, I should have my goddamn head examined for driving like this. Look, Carla, Candy, you gotta help me.
What can I do?
Take this, hold this.
What are you, high? No.
Fucking put this in your purse.
I'm not gonna put that shit in my purse.
He's not gonna search you. You didn't do anything. Now just put it in your bra.
I'm not wearing one.
Please, he's almost here. Just fucking put it in your pants. Just put it in your pants.
No.
You are the one that wanted to drive fast.
Read my lips. No.
After all I did for you, you fucking whore.
Who the fuck do you think you're
You know, our clients make it so easy for the police. It's ridiculous. Okay, here we go. This is 2C2-1C, possession. Possession is an act within the meaning of this section if the possessor knowingly procured or received the thing possessed or is aware of his control for a sufficient period of time to be able to terminate his possession. And you saw exactly that happening in this case. She doesn't want anything to do with this, and when he tries to give it to her, she just shoves it back at him. You know, she doesn't want constructive possession. She doesn't want any possession at all. Possession is an act within the meaning. So you've got to, you know, you really have to know that you possess it, and you have to know what it is. Because those are the two things the state's going to have to prove when you deal with these things. Interestingly, on the this Fourth Amendment issue, think about the elements of the plain view exception to the warrant requirement. Okay, law officer has to be lawfully in the viewing area. The discovery of the evidence has to be inadvertent, and he has to have probable cause to associate the discovery of the evidence with some violation of the law. It's really kind of an easy call. I want to talk about this movie for a second. Anybody recognize the movie? No? Let me tell you about this thing. What do you think, Dub? 1994? 93. Okay. The name of the movie is True Romance, and it's just a standard crazy movie, okay? I mean, there's nothing spectacular about it. It's just good entertainment, primarily. But what makes the movie utterly amazing is the number of people in this movie who were total nobodies when the movie was made and all became gigantic superstars. Okay? I mean, the movie had stars in it like anybody else. The stars in the movie were Dennis Hopper and Christopher Walken, who were always, they'd already been big stars, well established for a number of years.
Do you know who I am, Mr. Wally?
I give up. Who are you?
And Christian Slater, who was the male lead in the movie, he'd been, you know, kind of a mid-level star. He had a little bit of star power, I guess. Who was the young lady who was in this? Patricia Arquette. I'm not sure what happened to her career, but she was the love interest in this movie. Think about the number of people in this movie who became stars. First of all, the movie was written by Quentin Tarantino. Although he didn't direct this, you can see that he's got his stamp on every aspect of the movie in terms of the character development, the dialogue and all that's pure Tarantino. Plus the craziness of the plot is Tarantino as well. Here are some of the people that are in the movie. Let me know if I leave anybody out, okay? Brad Pitt. Val Kilmer.
As long as you're not at the scene of the crime, smoking gun in your hand, you get away with it. Clarence, I like you. I always have. Always will.
Our own Pride of Rutgers, James Gandolfini.
Do me a favor. Turn around for me.
Okay.
No, go the other way.
Okay.
Samuel L. Jackson, Gary Oldman.
You smoke enough sherm, your dumb ass will do a lot of motherfucking things. You be up in there sucking niggas' dicks.
Yo, man, fuck you guys, man. You guys is fucked up, right?
Yo, why you tripping? We're just fucking with you.
Lest I forget, because you pointed this out to me, a very young Jack Black.
Action-packed!
The Sonny kick ass or the Sonny kick ass?
Sonny kicks ass!
Show is over! Ma'am, this is not a hotel! Could you please wake up and go home?
I'm probably leaving 2 or 3 other people out. But I mean, just off the top of my head, I mean, you're just an amazing number of very talented big stars today, all in this movie with the little tiny parts to it. It's really kind of amazing. Good movie, a lot of fun. All right. You know, I want to talk about this for a second. You know, speaking about movies, we talk about what makes a successful movie. This Quentin Tarantino movie I was talking about a few moments ago, it has all the standard elements you need. You have to have star power in the movie. You have to have characters that the audience can identify with and become interested in. You have to have suspense, drama, comedy, sex, car chase, excitement is once in a while. Did I mention sex? All right. And happy endings. All right. Everybody loves happy endings, okay? True Romance has every one of those elements. It's necessary for successful marketing of movies. I mean, you're going to be successful commercially, you've got to have these elements in a movie. The movie we're going to take a look at now has none of those elements at all. Zero. It starts off bad, and by the end of the movie, you want to jump off a bridge, okay? It has no humor in it. It has no suspense. It has characters that you despise from minute one. The only thing it has in it is sex, and the sex is disgusting. Other than that, it's a great movie, okay? What makes the movie really bad, from my perspective, is that it's shot in a kind of a quasi-documentary style, which is fine. They wanted to give that feel to it. But it's such a deeply disturbing movie, A, because it's true. It deals with an unspeakable tragedy, a horrible crime committed by the stupidest people you could possibly imagine. And their complete lack of knowledge about the criminal justice system or any sense of morals. It's just like a whole bunch of kids that are like completely undeveloped in terms of their ideas of right and wrong. But let's get past that for a second. You'll get a little sense of what I'm talking about when we take a look at the scene. This deals with accomplice liability and complicity. Let's take a look and then we'll talk about it, okay? This involves two young girls, Claudia, who's going to, you'll see, be sunbathing in Florida, duh, and her friend Lisa.
Hey, Lisa. So what's up?
You're not gonna believe this shit, Claudia. You're not gonna fucking believe it. We killed Bobby.
Pardon me.
We killed him. He's dead. We did it. You just seen it. Marty just stuck him right in the heart.
Lisa, what are you talking about?
No shit. Listen. You know that guy, Donnie? You know, the loser? You met him. He even, like, he stuck him right in the back of the fucking head.
Lisa, what?
No, listen, it's so weird. This hitman, right? He takes this baseball bat, and right when Bobby's on the ground, and he's like gurgling like a baby, shooting blood, and his guts are like hanging out of him. And his eyes are so sick, his eyes were like popping out of his head. And he just takes this baseball bat and he swings it, and he just half caves in his head.
Did you watch this?
Yeah, I was there, and Allie and Heather were all there, and we saw it, most of it. Heather, you met her, right? She's so strange. You know, she gets this, like, blank look, like she's not even there, and she starts hugging her knees and rocking, and, like, she's totally fried, right? And then after, she just shrugs, and she says, you know, fuck him.
Lisa.
Hey, listen, Claudia. I'm real worried about how we left him. I mean, he's just out there where anyone can see him. I can't stop thinking about it, you know? Like someone just walking up and finding him. You know, we should have hit him better. We should have pushed him into the canal more. At least the gators would have gotten him, or he would have sunk or something, but... You know, that's why I came over.
What?
Oh, Claudia, I need to go out there. I mean, can you borrow your mother's car? I need a ride. I need someone to help me move it.
It?
The body.
You murdered Bobby Kent?
I didn't say I murdered anybody. I mean, they killed him. I wouldn't even say they murdered him. I mean, he was fighting back.
He was?
Yeah, I mean, he was trying to get away. And begging Marty to, you know, like saying, I'm sorry. Please, I'll do anything. Just don't kill me. Right when he said that, Marty just walked up to him and whacked him in the heart with his diving knife. The whole thing was just totally extreme.
Oh, wait. You want somebody to take you out there to move a body? I don't... Anybody that's crazy enough to do that is just
fine. We won't go move it. We'll just go out there and we'll see if the tire tracks are gone.
No way, Lisa. No way.
Come on.
No. Look, Lisa, I gotta go. I'm late for work. I'm supposed to be in Pizza Hut in half an hour.
Well, screw you, Claudia. I mean, all I wanted was a ride. I hope you have a problem someday so you can ask me for help. I mean, shit. I mean, you don't have to make a fucking federal case out of it just because I asked for a fucking ride. Oh, Claudia, keep your fucking mouth shut.
Oh, shit, Lisa.
Is that Lisa leaving?
Yeah.
Is everything okay?
Yeah.
What's going on?
Nothing.
What are you up to?
Nothing. Look, I gotta go to work, Mom.
This is what we call the mom exception to the Fourth Amendment, okay? Moms have the right to search your room anytime and interrogate you. Shouldn't lie to your mom. But as just a regular civilian person, she has no affirmative obligation to come forward and report this. Everybody kind of agree with that or disagree? By one of these amazing coincidences that can only happen in New Jersey, the seminal case dealing with that precise issue is this, State versus Lisa. Believe it or not, we had the good sense to name the case after the other character in the movie, okay? Which discusses that precise issue under the common law, and whether the common law obligation to come forward would also apply over to the New Jersey criminal law. The bottom line is, notwithstanding your argument, the appellate division would not impose an obligation on somebody who's utterly unrelated to it to come forward, all right? However, if you are related, for example, if, like, you're in the car and you know about it, you have an affirmative obligation to come forward and take action. There's civil liability for that. That's, again, one of these things that came up in the drunk driving context, okay? Now, question. Supposing that Claudia had said, okay, I'll go out there with you to let you take care of the tire tracks or something like that. We talked about the abolition of common law crimes, and one of the common law crimes that got abolished was the common law offense of accessory after the fact. That does not exist in New Jersey anymore. So, had she agreed to go out there knowing what the purpose was, would she have some type of liability, accomplice liability, co-conspirator, and if she's a conspirator or accomplice, what would be her, what crime, if any, would she have committed? Well, if she, let's assume that they're not going to move the body, she's going out there to cover up the tire tracks or something of that nature. So you might have, she's an accomplice in obstructing the administration of law or something of that nature. Hindering apprehension would be another one, right? Now, if she went there and helped move the body and threw it into the canal or something of that nature, then I agree with you. She's got these additional charges. Well, that's the other question that I'm thinking. Does that give her any exposure on the homicide part of it? I don't think that it does. I think the homicide is over at that point. But if she had agreed to go forward, she has all types of liability. Everybody cool with that? Conversely, though, if she has no affirmative obligation to do anything, to go forward and report anything or do anything. Does everybody agree? Let's talk about Lisa for a second, the one who's talking about this. Does she have any criminal liability? I don't remember whether he was over the age of 18 or not. I mean, they're all teenagers in the movie. What do you think? She may have conspiracy, right? You know, when you see the whole movie, you see that she's the leading, she's the, what do they call it, the entrepreneur here. She puts this whole thing together. It's all her ideas. She recruits everybody and motivates everybody, directs everybody. So she's the main character there. She does everything except kill the guy, all right? But from what you saw from here, she starts by saying, we killed him, we killed. She says it almost 3 times, the first words out of her mouth. Is there enough there to charge her with any type of criminal offense apart from being a material witness? What do you think?
Sounds like it to me, certainly to charge her.
Right. What do you think there, Mr. Persecutor?
If you have some type of agreement, some type of conspiracy.
Right.
At least conspiracy,
right. So you've got plenty going on here. It turns out later on this is going to be a flat-out murder case. But it's just, you know, sometimes the inferences you draw from these admissions of people, you know, they're not all that clear in the absence of other evidence. And what's funny to me is, you know, this is why these kids are so stupid. Don't they understand that every single syllable she's saying can be used against her in the prosecution of this case? And both of these young ladies now become material witnesses, okay? And both of them get locked up and held by the prosecutors because they have such critical information. It just shows you, you know, everybody should go to law school, or at least take this class. All right, let's see what we have next here. Okay. I wanted to talk about causation. And I had an idea for causation in a particular movie, but the problem was that it occurs in the context of a felony murder, okay? So the causation issues really don't make any difference because it's strict liability offense, okay? So I couldn't think of an example of something that would demonstrate this to the way so we could talk about it as lawyers. And I actually went so far as I went on Google and I said, give me the top 250 most popular crime movies of all time. And I looked at all of them, and nothing was ringing any bells. And then like a day or two later, I got in the shower, and the scene hit me, just out of clear blue sky, and I called Double A up, and he found the scene. So let's take a look at this scene, and then we'll talk about it in the context of causation under 2C2-3.
You ever seen that show, Cops? I was watching it one time, and there was this cop on. He was talking about this gunfight he had in the hallway with this guy, right? And he just unloaded on this guy, and nothing happened. He didn't hit nothing. Okay, it was just him and this guy. I mean, you know, it's freaky, but it happens.
Look, you want to play blind man, go walk with a shepherd. But me, my eyes are wide fucking open.
What the fuck does that mean?
I mean, that's it for me. From here on in, you can consider my ass retired.
Jesus Christ.
Don't blaspheme.
God damn it,
I said don't do that.
Hey, you know, you're fucking freaking out on us.
Look, I'm telling Marcellus today. I'm through.
Well, why don't you tell him at the same time why?
Don't worry, I will.
Yeah, and I bet you $10,000 he'll ask his ass off.
I don't give a damn if he does.
Marvin, what do you make of all this?
Man, I don't even have an opinion.
Well, you gotta have an opinion. I mean, do you think that God came down from heaven and stopped you?
Oh, what the fuck's happening?
Oh, man.
Shit, man.
Oh, man, I shot Marvin in the face.
Why the fuck you do that?
Well, I didn't mean to do it. It was an accident.
Oh, man, I seen some crazy ass shit in my time, but this...
Chill out, man. I told you it was an accident. You went over a bump or
Hey,
something.
the car ain't hit no motherfucking bump.
Hey, look, man, I didn't mean to shoot the son of a bitch. The gun went off. I don't know why.
Well, look at this fucking mess, man. We're on a city street in broad daylight here.
Believe it, man.
Well, believe it now, motherfucker. We gotta get this car off the road. You know, cops tend to notice shit like you're driving a car against this fucking blood.
Just take it to a friendly place, that's all.
This is the valley, Vincent. Marcellus ain't got no friendly places in the valley.
Well, you say my fucking town, man.
Shit.
The key issue that I don't want to use the word supersedes either, that kind of defeats the idea of intervening causation here is the foreseeability, that this is entirely foreseeable.
And it's a deadly weapon.
Right. But over and above that, though, when you have a weapon pointed at somebody and you've got your finger on the trigger in a moving vehicle, it's entirely foreseeable you're going to go over a bump and the weapon's going to discharge. In fact, the weapon could discharge even if you don't go over a bump. Nobody here seems to have any problem that this guy acted recklessly, okay? Now, the question is, what crime did he commit? Is this regular manslaughter or is this aggravated manslaughter? Okay. But everybody see from the legal issues, there is no right or wrong answer to this stuff, okay? I mean, you can see what's going on here. These are jury questions. This is where the art of advocacy comes in. And you're going to argue to the jury to, if Tommy, you're going to argue one way, Bob, you'll argue the other. I'm going to argue that it was disorderly persons offense, but I don't think nobody's buying that. The negligent discharge of a firearm. All right. Let's see what we got next. Okay. This is another Quentin Tarantino movie, same movie actually. Requirement of voluntary act omission as basis of liability and possession. But I want to talk about this also. Think about this scene as you watch it in terms of foreseeability. Okay? Foreseeability. Let's take a look. It speaks for itself. The only setup you need to know, John Travolta and Uma Thurman have been out on a very lovely date. They've engaged in the very famous twist contest.
C'est la vie, say the old folks. It goes to show you never can tell. They had a high-five phone, oh boy, did they let it blast.
Which is now an iconic scene in the movies. They've won their award. She's cold coming back to her house because it's a little bit chilly that night. So he gives her his raincoat. So she's wearing his raincoat. That's all you need to know. Let's take a look.
Drinks, music.
I'm gonna take a piss.
That's a little bit more information than I needed, Vince, but go right ahead.
You'll be a woman soon. I love you so much, can't count all the ways I died for you, girl, and all they can say is he's not your kind. They never get tired of putting me down, and I never know when I come around what I'm gonna find. Don't let them make up your mind. Don't you look good?
One drink, and that's it. Don't be rude. Drink your drink, but do it quickly. Say goodnight and go home.
You'll be a woman soon. You'll be a woman.
This is a moral test of oneself, whether or not you can maintain loyalty. Because being loyal is very important.
Never get tired of putting me down, and I never know when I come around what I'm gonna find. Don't let them make up your mind. Don't you look good? You'll be a woman soon. Please come take my hand.
So, you're going to go out there, you're going to say goodnight, have had a very lovely evening. Walk out the door, get in the car, go home, jerk off, and that's all you're going to do.
Let that be a lesson to all of you. This is what happens when you snort pure heroin thinking that it's cocaine, all right? Now, a couple of questions for you. Not to belabor the obvious, but we have all kinds of drug problems with John Travolta, okay? Forget about that part. What homicide crimes, if any, do we have here? Do you have a homicide crime here? What do you think? Well, there's no evidence that he shared it with her. There's no evidence that there's a distribution here, which would be required for the strict liability for drug-induced death. So I think he probably has a pretty good defense in terms of the strict liability offense. But are there other homicide crimes that he could be charged with here? Okay? Well, let's think about it. Certainly not purposeful conduct. It was not his conscious object to bring about that result. It wasn't knowing. He didn't act knowingly here. It wasn't certain or practically certain that it was going to occur. So there's no such thing as negligence in terms of a homicide in New Jersey, so we're left with recklessness. Did he act recklessly under the circumstances here? Now, in the movie, he purchased this pure heroin, and because of the not having the necessary paraphernalia, so to speak, the guy he bought it from packaged it in a bag that you would normally package cocaine in, as opposed to what you normally, like a balloon that you would put heroin in, okay? He puts it in his pocket, and there it is. He then later gives this young lady his coat to wear without warning her that he's got this dangerous instrumentality inside of his jacket. Okay? Now, if it were a firearm or a hand grenade or something like that, I think it would be reasonable to say, listen, you can wear my coat, but just keep your hand out of my pocket. There's a hand grenade in there, okay? Or I have an AIDS-tainted needle in there. Keep your hand out of my pocket, okay? Do you think it would be reasonable under the circumstances for him to have warned her that he has this heroin in his pocket? Would it be reckless not to do so? You don't think so? Okay. Tommy, what do you think? There's no doubt it's her volitional act, but did he act recklessly in having it there and not informing her that it was in his pocket? Boy, you guys are like such easy prosecutors. I'm thinking like breathing fire, you know. I thought you'd be like making a noose up already, you know? No way? Okay, now, let's not change the facts, but let's look at it, let's all, for the sake of argument, assume that he acted recklessly, okay? That he had an affirmative duty to tell her that he's got this dangerous instrumentality there. Is it foreseeable that she would go into his pocket, take it out, and snort it? Even in the absence of, you know, assuming that he's reckless not telling her. Is it foreseeable? Or is this just too much of a stretch of the imagination that people would not anticipate that she'd go in the pocket, pull it out, and then snort it. What do you think? She knows not to snort pure heroin, right? But she thinks it's cocaine. See, that's her problem, you know? That'll teach her a good lesson.
And I'm out of balloons. Is a baggie all right? Yeah, that's cool. Just get one for you. Honey?
All right. Conspiracy. Conspiracy. Now, here's the setup in this movie, okay? This is really a wonderful low-budget movie starring Brad Pitt. There is a criminal enterprise that runs a lot of illicit activities in a particular town. One of the activities that they supervise are underground poker games, okay, which are played all over the place. One particular poker game gets knocked over by a crew of robbers. They take the pot, they rob all the players, and things of that nature. And the the criminals who run this, I guess you call them an organization for one, a syndicate, maybe that's the best word to describe them, they're mad about it and they want something done. They have an attorney who represents them, and the attorney goes out and recruits a hitman, but the hitman's not available because he's sick, so he sends a substitute hitman to talk to the attorney about what they're going to do about these guys. All right? That's all you need to know. That's the setup here.
We talked to Dylan. We both think now. Okay. Whack Trapman, get the game started up.
Trapman? What brings Trapman into this? You just told me that it was this squirrel fella and his two friends.
It is. Plus, I had Trapman talk to him. Yeah. I'm sure.
You ought to be. Your boys went a little overboard there. They damn near killed the man.
It wasn't my idea. Waste of time, I said. Waste of money, I said. Why put Marky through it, I said.
You know, he called me up. I had trouble understanding him. Hell, I had trouble calling him back because he got my secretary the first time. She couldn't understand him. The numbers he left, he's got a broken jaw.
I heard that.
Got broken ribs, he got a broken nose, 3 or 4 broken teeth. There was some question about his spleen, he said. He was in the hospital when I talked to him. He's out now, I understand.
Must be his spleen's okay then.
You know, he's not happy, though.
I'm sorry to hear that. We aim to please.
That's what I'm supposed to tell him?
Tell him whatever you want. Won't make a bit of difference anyways. Trapman's got to be hit, and they know it.
You know, that, you see, I don't understand that. I mean...
Do I have to explain this twice? What do you think the guys on the street think?
I got no idea.
They think Trapman. He did it before, and now he did it again, and all he got was beat off.
He didn't really do anything.
It's his responsibility. He did it before, and now it happened again. So he's responsible for what guys think. On the street, it's Trapman. Nothing but Trapman. Look, there's no two ways about it, counselor. Trapman's got to be hit. He made a mistake.
Oh, wait a minute. I get it. I see what you mean. The public angle and all. Okay. Okay. If they agree with you, assuming that, can you hit Trapman?
Sure.
And what about this squirrel fella? Because he seems like the leading candidate to me.
Probably not any Mickey for that one.
Mickey? New York Mickey? Why can't you handle?
Because Squirrel knows me. Didn't I say that already? He needed something done once. Dylan couldn't do it, so I did it, so he knows me. He's gonna figure if he's waiting on someone, he's waiting on me or Dylan.
So what?
You ever killed anyone?
No.
You can get touchy-feely.
Touchy-feely?
Emotional, not fun. A lot of fuss. They cry, they plead, they beg, they piss themselves, they call for their mothers. It gets embarrassing. I like to kill them softly. From a distance. Not close enough for feelings. Don't like feelings. Don't want to think about them. We need Mickey. What's the problem?
Mickey's expensive.
Not at the moment.
You get him for 10?
15.
You do it for 15?
15, asshole. I think in this economy, a quick 15 for 2 days' work would sound pretty good to Mickey. We'll sell him a party. Fly in, whack a guy, fly out. Quick 15.
Fly coach.
It's amazing that even the prices of hitmen are subject to market forces and the vicissitudes of our economy. You know, I mean, it's... So, question, do we have a conspiracy here? And if we do have a conspiracy, who are the conspirators? Remember, you got an attorney who's speaking for a bunch of people. Notably, he said, if they agree, or assuming they agree, have they gone far enough into this to have a conspiracy? See, these are the problems that you run into with inchoate crimes. And this is one of the changes in the common law that we'll see in a second in the code, where normally under the common law you'd have to have an act in furtherance of the conspiracy, okay? But the modern view in New Jersey is inchoate crimes are so dangerous that as a matter of public policy you want to cut them off as soon as possible before people start getting hurt, robbed, killed, whatever it may be. So the policy is to basically cut them off and end them at the earliest possible time, especially with crimes of the first or second degree. So here's the definition in 2C5-2. Person is guilty of conspiracy with another to commit a crime if with the purpose of promoting or facilitating his commission, and that's what they have here. He agrees with such other persons that one or more of them will engage in conduct which constitutes such crime or attempt or solicitation to commit such crime, or agrees to aid such person or person the planning, commission of such crime or attempt to solicit. Okay? Here's the overt act requirement, which was, this is a change from the common law. No person may be convicted of conspiracy to commit a crime other than a crime of the first or second degree, or distribution or possession with intent to distribute, unless an overt act in pursuance of such conspiracy is proved to have been done by him. So really, you're going to need this for third and fourth degree crimes. You cannot conspire to commit a disorderly person's offense. Okay, it's only for crimes. All right, interesting legal issue in this case. All right. Now, Bob, this has a very significant firearms question. We're going to talk about it in a second. We're going to have a little quiz after this, and I'm going to ask you, these are the questions on the quiz. What crime, if any, was committed here? And if a crime was committed, would it constitute an act of domestic violence? Those are the two questions, all right? Here's the setup. Secretary and boss have always had a professional relationship with each other, okay? They have agreed to go out on a date, and I use that in quotation marks, okay? And so the boss is now making reservations for them to go have dinner. All right? Very simple. Take a look and then we'll talk about it. Keep those two questions in mind.
Dorcia?
So, Dorcia is where Jean wants to go.
Oh, I don't know. No, we'll go in wherever you want to go.
Dorcia is fine.
Dorcia, yes?
Yeah, can you take 2 tonight at, well, let's say 9 o'clock?
We're totally booked.
Really? That's great.
No, I said we are totally booked.
2 at 9? Perfect. See you then. Yeah. You're dressed okay?
You didn't give a name.
They know me. Why don't you meet me at my place at 7 for drinks? And Jean, you'll want to change before we go out.
Patrick, it's so elegant. What a wonderful view.
Jean? Sorbet?
Thanks, Patrick. I'd love some. Do you want a bite?
I'm on a diet, but thank you.
No need to lose any weight. You're kidding, right? You look great. Very fit.
You can always be thinner. Look better.
Well, maybe we shouldn't go out to dinner. I don't want to ruin your willpower.
That's all right. I'm not very good at controlling it anyway. So listen. What do you really want to do with your life? Just briefly summarize. And don't tell me you enjoy working with children, okay?
Well, I'd like to travel and maybe go back to school, but I don't really know. I'm at a point in my life where there seems to be so many possibilities, but I don't know, I'm just so unsure.
You have a boyfriend.
No, not really.
Interesting.
Are you seeing anyone? I mean, seriously?
Maybe. I don't know. Not really. Jean, do you feel fulfilled? I mean, in your life?
I guess I do. For a long time I was too focused on my work, but now I've really begun to think about changing myself, you know, developing and growing.
Growing. I'm glad you said that. Did you know that Ted Bundy's first dog, a collie, was named Lassie? Had you heard this?
Who's Ted Bundy?
Forget it.
What's that?
Duct tape. I need it for taping something.
Patrick? Have you ever wanted to make someone happy?
What? No, put it in the carton.
Sorry.
Jean? What?
Make someone happy. Have you ever wanted to?
I'm looking for, I guess you could say I just want to have a meaningful relationship with someone special.
Patrick, I know you're there. Pick up the phone, you bad boy. What are you up to tonight? It's me. Don't try to hide. I hope you're not out there with some little number you picked up because you're my Mr. Bateman. My boy next door. Anyway, you never called me and you said you would. And I'll leave a message for Jean about this too to remind you, but we're having dinner with Melania and Taylor. You know Melania, she went to Sweetbriar, and we're meeting at the Cornell Club, so I'll call you tomorrow morning, honey. Oh, sorry, I know you hate that. Bye, Patrick. Bye, Mr. Big-Time CEO. Bye-bye.
Was that Evelyn? Are you still seeing her? I'm sorry. I have no right to ask that. Do you want me to go?
Yeah. I don't think I can control myself.
I know I should go. I know I have a tendency to get involved with unavailable men. And, I mean, do you want me to go?
I think if you stay, something bad will happen. I think I might hurt you. You don't want to get hurt, do you?
No, I guess not. I don't want to get bruised. You're right. I should go. Oh, don't forget you have a lunch date tomorrow with Donald Kimball at Smith & Walensky's.
Thanks. It slipped my mind completely.
Was there a crime committed here? Wow, that's a bold statement. And beyond having a predicate offense, do we have any offense that was committed here? She doesn't know. She doesn't know anything, all right? But that doesn't necessarily mean there wasn't an offense committed here. He certainly had every intention of killing her. When you stop to think about lying about the reservations for dinner, which he knew they were never going to go to in the first place, he's obviously killed somebody before. He's got the duct tape, you know. Nail gun. Nail gun, okay. So, what do you think? Could you make an argument that a nail gun meets the definition statutorily of a firearm under Chapter 39 of Title 2C? Well, let's take a look at the definition. I think I have the definition of firearm here in our materials. All right, this is what a firearm is under 2C39-1. Handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun device or instrument in the nature of a weapon from which may be fired or ejected any solid projectile, ball, slug, pellet, missile, bullet, or any gas, vapor, or other noxious thing by means of a cartridge or shell, or by action of an explosive or other of the letting of flammable or explosive substances. It also includes without limitation any firearm which is in the nature of an air gun, spring gun, pistol, or other weapon of a similar nature in which the propelling force is a spring, electric band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air, and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure. So I guess the key description here, it would have to be a gun or instrument in the nature of a weapon in order to be a firearm. I mean, if you look at it, the nail gun has many of the attributes of a firearm. It's using, in New Jersey, it uses compressed air. I know they have some of these nail guns use gunpowder to, yeah. But believe me, I mean, listen, a nail shot out of one of these things by compressed air can put a hurting on you, okay, especially when it's going into the back of your skull. Could you make an argument based upon the statutory definition that a nail gun is a firearm? Because if you get to that point, you can comfortably argue you've got a fourth-degree Graves Act pointing going on here, all right? Yeah, I don't know what they mean by missile. It's certainly not aerodynamically designed, like a typical bullet would be. Or a missile is aerodynamic in nature. The bullet is not, the nail is not for that purpose. You guys are changing my mind on this, and I don't like it at all. Because I thought you had a really strong argument you could make up this for a firearm, and now I'm not so sure at all. I have a reasonable doubt. This is why I'm changing my mind about all this stuff, because if you look at it, it's really kind of nuanced, but device or instrument, again, as you're saying, it has to be in the nature of a weapon, and the nail gun is not in the nature of a weapon. Otherwise, it would be a Graves Act offense for every carpenter that's out there, because nobody uses a hammer anymore, okay? So, I guess, are you guys going to make the pitch that this is not a criminal offense? It's at least not a Graves Act offense? But what about the diameter of the projectile, though? Doesn't that take it out of the definition? Because I think about that in the context of paint guns. All right, let's go one step further. Let's assume, for the sake of argument, we're going to make an argument that this is it's an aggravated assault. Okay, fourth-degree Graves Act. Is it an act of domestic violence? Okay. In other words, we're going to assume, for argument's purposes, that we have the predicate offense, criminal offense, the assault of conduct. Is it an act of domestic violence? What do you guys think? She'd have to be pregnant by him, married, used to be married, kid in common. The only one that's really going to lock them into this one is dating relationship. Right. So do these people have a dating relationship? Does the fact that they're on a date, so to speak, or I don't know if their date ever actually began. There is a case on it. Mm-hmm. There is an appellate division case on it, and this is a dating relationship was never defined by the legislature. They let the case law decide the issue. What I'm thinking about here is you could see that throughout this entire thing, I don't think they ever really cracked the veneer of boss, subordinate in their dealings with each other. His yelling at her, to put the spoon in the container. Her last words to him walking out the door were secretary words. Don't forget you've got this appointment tomorrow at Smith and Wall. They never changed their relationship from one of boss and subordinate. So I don't know whether they really technically were out on a date or had a dating relationship within the meaning of the statute. Okay? And I'm not advocating anything here. I'm just posing questions for you guys as advocates in case this ever came up. Everybody cool? All right. This movie was on last night, and I watched it. And I have to talk about it for a few seconds, and I hope you guys will indulge me. I have to tell a little personal story. When I was a very, very small child, 5, maybe 6 years old. My parents went to see this movie in the movies. So this is a 1951 movie, so this was probably in the mid-50s when they went, and they took me. And I remember to this day being very upset by the outcome in the movie, because I thought the guy was innocent and kind of got railroaded. And I'm looking at it as a child, but also as a non-lawyer child. And I watched it again last night, and I've completely changed my mind on it, because now I look at it as an attorney would look at these things, especially an attorney who's used to dealing with the way things go down in the criminal justice system. So let's take a look at it and talk about it. This is dealing with homicide under 2C11-2. Here's the setup. Montgomery Clift plays a very good-looking man, young fellow, who's related to some people who have a lot of money. But his part of the family is, they're from the poor end of the family, so to speak. He goes to visit them, and they offer him a job in a factory that they own, and he works in the mail room of the factory, or the room where they box stuff up and ship it out to people. But he has designs on moving to a much more comfortable upper middle class life. While he's working in the shipping department, he meets a very plain Jane young lady played by Shelley Winters, who won the Academy Award for this for Best Supporting Actress. And ultimately she winds up getting pregnant by him. While he's carrying on his affair with her, he happens by chance to meet a 19-year-old, unbelievably beautiful Elizabeth Taylor, and falls in love with her. And he has a very, very hot romance with her. She's everything he wants, not only because she's Elizabeth Taylor, but also she's in the upper echelon of society. This movie really deals quite a bit with the societal class structure of the United States in that era. He's got to get rid of this crazy woman that who's now he's impregnated, and they get married, and to celebrate their honeymoon, he decides he'll take her out for a picnic and a row on the lake. Although in his mind, he wants this to be a one-way ride for his new wife, okay? Let's take a look at this, and then we'll discuss the legal aspects of it, all right? Oh, yes, sir.
She can't swim.
Who can't swim?
Shelley Winters.
Oh, that's part of the thing? She can't swim. All right. In real life, she couldn't swim either.
I know it isn't easy for you. I shouldn't have said that.
Stay where you are.
Or was the boat as far as from here to the bailiff?
I guess so. I don't know.
Do you mean to tell me you couldn't swim this little distance to this poor, weak girl and buoy her up till you could reach this boat just 15 feet away? I'll tell you one thing, you know you're lying. She was drowning and you just let her drown.
I object.
She was sitting there defenseless in the back of the boat, and you picked up this oar like this and you crashed it down on that poor girl's head like... You pushed that poor girl into the lake. You watched her drown. Isn't that the truth?
No.
That's all, Your Honor.
That jury does not look happy with him at all. So as a child, I'm looking at this movie and I say, no, that's not what happened. He didn't want to kill her. You know, it's just an accident. But everything in the movie, when you watch the movie, you see that everything in the movie shrieks guilt. Shrieks it, okay? If you look at all the circumstantial evidence here, he pulls up to the place, because again, he intends it to be a one-way ride for her, gives a false name for the two of them, takes her out on the lake, keeps it out there till dark, makes sure that nobody else is on the lake at that particular time. In fact, inquires about that. She dies. He swims out of the lake, gets back in his car, takes off, doesn't report it, and takes steps basically to cover up the entire thing. Okay, so a jury looking at this, they didn't see what happened in the boat. All they got is his side of the story is, well, I originally intended to kill her, but I didn't. It was an accident. Okay, guilty. All right, I mean that's just the way these things go. Guilty, guilty, guilty. You know, in our system, guilty doesn't have anything to do, or guilt doesn't have anything to do with objective truth. It has to do with levels of belief. Is the jury going to believe that this guy, you know, is his story? You know, look at the circumstantial evidence. It puts the lie to everything he said. So, just the way facts are proved in our system of justice. But looking at it in purely objective form, which you never get in the courtroom, unless you have a videotape, is the guy guilty of anything? Did he commit a criminal offense here? What do you think? He's got the purpose. His purpose for being out there in the first place is to kill her. This is just one of those situations where the actus reus doesn't match up with the purpose, okay? In fact, you can see he makes some statements to her which you can draw the inference that he's really kind of abandoning, renouncing his criminal intention while they're on the boat. So what do you think? A criminal offense here or just a pure accident?
Push her out of the boat or drown her.
Right. All right. Can I tell you one thing about the movie? At the end of the movie, this being 1951, you know, the killer always has to have justice. So he's being led off to the electric chair to be electrocuted, and his last thoughts in life are of this beautiful 19-year-old Elizabeth Taylor. And I'm going to tell you guys something. My last thoughts in life are also going to be about Elizabeth Taylor, okay, at age 19. Mark my words. So unbelievably beautiful. All right. Let's see what we have here. Okay. Now, here's another this is a pop quiz. Watch this scene and tell me what we've got here. Okay? Do we have murder, aggravated manslaughter, or no crime? Okay? Everybody got it? Take a look and let me know what you think.
No. It's Dave, D, Dozy, Beaky, Mitch, and Titch. So you got it? Thanks, honey. You're gonna play it next song, right? Good boy. Growl. Bye-bye. Who do you want to hear? Dave, D, Dozy, Beaky, Mitch, and Titch. Who? Dave, D, Dozy, Beaky, Mitch, and Titch. Who the fuck are they? For your information, Pete Townsend at one point almost quit The Who, and if he had, he would have ended up in this group, thus making it Dave, D, Dozy, Beaky, Mitch, Titch, and Pete. And if you ask me, he should have. That's my boy!
Count of three, gotta stay close by me and hold tight, sing and shout, just wrap around the crowd and hold tight, shut your eyes, girl, you shut me up, cause I forget the other guys, you'll never fall, this time you call, hold tight, hold tight, hold tight, what you say is for real and hold tight, carousel, you'll send me and my bell and hold tight, cable car, sing it low, swing it high, we're gonna make the sky, you'll never fall.
Murder, aggravated manslaughter, vehicular homicide, manslaughter, or no crime at all? What? All the girls die. Yeah, the guy who's in the other car lives. Because he's in a death-proof car. It's the name of the movie, Death Proof. All right? Quentin Tarantino, what do you expect? You know? Don't blame me for the director. Yes. This is a mad slasher movie, except instead of losing a knife, he uses a car. Murder? Why?
Shut the lights off.
Well, maybe it was he wanted to save conserve electricity.
Went full speed, head on.
Right?
That was his purpose. I think that was his purpose.
Were you offended that he passed to the double yellow line? You know that's a 5-point offense. So, all right, so he lies in wait, okay, shuts off his lights so they won't be able to evade him, goes at full speed, turns on his lights at the last second for a dramatic effect, all right?
Probably get the blind to drive.
So, let's talk about murder. We got the death of human beings here. What was his culpability state? Your argument is that he was acting purposefully, that the fact of lying in wait, shut off the lights and things like that, demonstrate that this was his conscious object to bring about their deaths. Or that it was knowing, in the sense that he knew what he was doing, he knew he was driving, and he knew that under the circumstances, this result was certain or practically certain to occur. Everybody agree?
Plus the way he had rigged his car.
And the way he had rigged his car. Good point. So, everybody says murder? Nobody wants to make a, like careless driving here or anything like that? But you see, I'm putting these, so we're building as we go through here to look at all these elements and how they all play out and the evidence utilized to prove these different elements. That's how you have to analyze these cases when you're kind of looking at them and thinking, how am I going to defend this thing, all right? Okay. Send it back to municipal court, sorry. It's just speeding. He's in big trouble because of the WO line. We're going to be talking about Tony Montana, a political prisoner from Cuba, all right? This is an easy case in terms of the police officer. He's going to be soliciting a bribe. So you got official misconduct and bribery and things like that. I'm more concerned about whether or not you think Tony Montana is guilty of any type of criminal offense for the transaction you're going to watch. Pay particular attention and make a decision as you think whether Tony Montana is guilty of a crime. Take a look.
My office. Good. The word on the street, Tony, is you're bringing in a lot of Yale. That means you're not a small-time punk anymore. Public property now. Supreme Court says that your privacy can be invaded. Okay, how much? How much? Well, there's an answer to that too, Tony. This is how much. That's it. Big number. Yeah. It's on a monthly basis, same thing every month. You know how this works? No, just tell me. We tell you who's moving against you. And we shake down who you want shaken down. Now, let's say that you got a real problem making a collection, all right? And then we step in for it. I got 8 killers with badges working for me, and when they hit, it hurts. Same thing works the other way. You feed me a bust now. Some cowboy's setting himself up in business. A small fry, you know? We like snacks.
How do I know you're the last cop I'm gonna have to grease? What about Fort Lauderdale? Metro? DEA? How do I know what rock they're gonna call out from on?
Well, it's not my business, Tony, you know. We don't cross no lines. Listen, you think I want this conversation going any farther than this table? My guys got families. They're legitimate cops. I don't want to see them embarrassed. They're embarrassed, they're going to suffer. And if they suffer, they're going to make you suffer. Comprendi? You understand what I'm talking about? Huh? Give it a drink. By the way, got a vacation coming up. I'm gonna take the wife to London, England. You've never been there. So throw in a couple of round-trip tickets, first class. You gotta smile more, Tony. You gotta enjoy yourself. Every day above ground is a good day.
I didn't see him agree to anything. He has 2 questions, and it's pretty obvious if you look at what was going on, his mind is not in this at all. He's not paying attention to the other guy at all. He's watching the crowd, he's watching who this girl's dancing with, you know, the young lady plays his sister. The love interest comes in. There's a whole bunch of stuff going on, and this is just stuff that is not on his mind. Police officer's probably also guilty of extortion as well. I want to commend to you this Camerano case from the Supreme Court from late last year. They set forth what they think is a new rule of law, which is not, that attorneys who are involved in bribery of public officials are going to be disbarred in every instance. That is not a new outcome, because that's the way it's been for many, many years. The Supreme Court just always disbars attorneys who are involved in bribery of public officials. But they've made it like a kind of a rule of law now, very similar to In re Wilson. So that's going to be the outcome if you're convicted of a bribery, which is very important because, just to give you an example, we're working with a case now with an attorney who was indicted in Camden County, and there's a whole bunch of counts, some of them bribery counts, bribery of public official counts. And trying to deal with the case is fine, but you've got to plead guilty to stuff that does not involve bribery of a public official, because that's going to be the end of this guy's law license. If he pleads guilty to something else, some kind of a theft offense or something of that nature, you know, he has a chance of practicing law again. But if it's bribery of a public official, forget about it, okay? All right. I want to talk about consent, okay? Consent, especially when you're dealing with assaultive type conduct. Now remember, you've got to make sure that the person who's involved on the other side has the capacity to consent to the conduct. When you're dealing, for example, with sexual issues, you know, children under a particular age, I think it's under the age of 16, depending upon the age of the other person, don't have the capacity to consent to engage in sexual activity. So you assume going in that the person has statutory capacity to give consent. But once you do, consent's a complete defense. Let's take a look at this very famous scene. And by the way, quick trivia question. What is the first rule of Fight Club? What's the second rule of Fight Club? See why she's a prosecutor? She knows this stuff.
Oh, it's late. Hey, thanks for the beer.
Yeah, man.
Okay. We should find a hotel. Oh.
What?
What?
A hotel.
Yeah.
Just ask, man.
What are you talking about?
3 pitchers of beer and you still can't ask.
What?
You called me because you needed a place to stay.
Oh, hey, no.
Yes, you
I
did.
didn't mean...
So just ask. Cut the foreplay and just ask, man.
Would that be a problem?
Is it a problem for you to ask?
Can I stay at your place?
Yeah.
Thanks.
I want you to do me a favor.
Yeah, sure.
I want you to hit me as hard as you can.
What?
I want you to hit me as hard as you can.
What do you want me to do? You just want me to hit you?
Come on, do me this one favor.
Why?
Why? I don't know why. I don't know. Never been in a fight. You?
No, but that's a good thing.
No, it is not. How much can you know about yourself? You've never been in a fight. I don't want to die without any scars. So come on, hit me before I lose my nerve.
Oh, God. This is crazy.
So go crazy. Let her rip.
Hey, I don't know about this.
I don't either, but who gives a shit? No one's watching. What do you care?
Wait, this is crazy. You want me to hit you?
That's right.
What, like in the face?
Surprise me.
This is so fucking stupid.
Motherfucker! You hit me in the ear!
Well, Jesus, I'm sorry.
Ow! Christ! Why the ear, man?
Ah, I fucked it up.
Oh, that was perfect. Oh! Ah!
That really hurts.
No, you hit me. Come on!
this again sometime.
So under 2C12-1A1, the offense of, it's a petty disorderly person's offense, assault by mutual conduct, which you get when these guys are in a scuffle, slugging it out with each other. But occasionally you can work these things out. If the guys will say, listen, you weren't really fighting, this was consensual. You can utilize this as an affirmative defense. Remember, it's an affirmative defense. It's not something the state has to prove as part of its case. The defendant has to put this in evidence, and then it becomes incumbent upon the prosecutor to disprove it beyond a reasonable doubt. All right? All right. Entrapment. Take a look at this case, and I want you guys to tell me whether or not you think the person here, the mayor, quote unquote, was entrapped. This, I'm very proud to tell you, is a New Jersey case involving the former mayor and Assemblyman Angelo Arricchetti, a beloved figure in that era, mid-1970s, I guess this was, in the city of Camden, and a Assemblyman from Camden County. And this is part of the abscam investigation. Take a look and tell me whether or not you think he was entrapped.
Well, excuse me. I'll handle that for the mayor.
No, it's for the mayor. It'd be a sign of disrespect to the sheik if the mayor didn't take it. It's for you, Mayor.
What are you doing? Carl, what the fuck? What is this?
I'm gonna take care of it. Everything's good. I got everything under control.
Whoa. Hey. What is this?
I'm gonna
handle
this.
What is this?
I don't know.
I don't know you. I don't know what the fuck that is, but it's weird. You understand?
Misunderstanding.
Look, I came here to meet a sheik. That's all I know. I'm very interested in that, but he's not here apparently. You call. You know what I mean? This is not right. Look, I'm very interested in meeting in this sheik. You let me know when that can happen. Okay? Thank you. Have a good day.
You better come get him. Go out there and get him right now.
Help me get him back. Get him. Go get him.
I didn't want to do this in the first place. This is your show. You go get him.
No, you have no choice. You have to go get him. Now go get him so he takes the briefcase by himself. That's the whole plan, Irving.
What were you doing pushing the fucking briefcase, dummy? Huh?
But the whole fucking thing was falling apart. You know how much it fucking costs for this goddamn hotel that you fucking asked for?
No, I gotta go mop up your mess. I'm gonna go fucking mop up your mess.
Mr. Mayor, please stop. Listen, I apologize if that prick offended you. I really apologize.
All right, thank you.
No.
Okay.
I'm fucking embarrassed to be associated with that guy at all. Can I just say something to you, please? Don't lose this opportunity to fucking Florida, all right? Because of some bullshit from that punk advisor, all right, with his diploma, all right, who could never get into the school that we come from. Don't lose that opportunity.
Where are you from?
From the Bronx. Grand Concourse, 164th Street.
I got a lot of friends that live up there. Yeah, I go to Tommaso's on, you ever go to Tommaso's on Arthur Avenue?
No, the clams.
The spicy clams. Oh, the fucking die for those things.
Yeah.
Yeah, I haven't been there in a while. I like that place.
You know what? Carmen, can I call you Carmen? Oh, Carmen. Hey, my fucking heart's going from running down the stairs. I'm not used to running. There's a lot of green grass in that hotel room up there, all right? And all the deals would flow through you. You get a serious piece on both ends, all right? You do with that what you will. And I live in the real world, all right? I am a family man. I got mouths to feed and everything like that. But, you know, we gotta agree shit directly. No middlemen, no bullshit. It's the Arab way. That's it. All right?
Yeah, look, I understand. It's a great opportunity. You understand? It's just I got a little thrown by going to have a meeting with somebody that ended up being there.
Hey, listen, I was thrown as well.
I understand. I'll deal with you directly. Or any middleman, any of that bullshit.
Done.
I'll deal with you directly.
Done. You and me.
I like you. Eye to eye. We can do business together.
Okay, so we have entrapment here. He's gone. He's out the door. There's nothing to do with it. And they chase him down like a dog in the street and twist his arm and make him take that bribe. What do you think? You got a good argument here for entrapment? Or do you think he was predisposed to commit the offense in the first place? What do you think, Johnny?
He understood he was going to get greased.
Yeah, he did. But he was out the door. He was gone. You know?
Only because he thought it was chic.
Well, he just didn't like the whole setup, you know? So, just something to think about. Again, these are all jury questions. Bob and I were talking about this in the break, and you hit it right on the head. I mean, so many of these issues we're talking about, there is no right or wrong answer. You can go any way. It's the advocacy, the power of your advocacy, that's really going to make these decisions. These are jury questions, okay? Who's to say whether it is or it isn't? All right, there's the statute, though, 2C2-12. Certain persons, apparently in New Jersey, certain people are not allowed to possess firearms after they've been convicted of offenses, acts of domestic violence, certain drug offenses, certain serious crimes. They're prohibited from possessing weapons. So whenever this happens, they're designated as certain persons. Certain persons charges are tried on a bifurcated basis so as to not kind of let the jury know that the guy has a prior criminal conviction. Typically, they'll try the underlying offense first, and after that's over, they'll come back and try the certain persons aspect of the case, because then they can reveal that he had a prior offense which made him a person that was ineligible to possess firearms. Let's just take a quick look at a typical certain person situation.
So they grabbed me down in Maryland on this gun thing.
What gun thing?
Well, let's go hunting for Christ's sake. Me and this guy, Topper. You know Topper?
No.
Nice guy. Anyway, we're going down to Maryland to hunt geese down the Maryland shore. And we go down there, and all of a sudden there's a couple hundred cops all over the place, and I got the shotguns in the trunk. Fucking beautiful, Fucking shotgun. I just bought the fucking shotgun. I never even used it once. Now, boom, I'm under arrest. Felon in possession. So I'm gonna go to jail for a fucking shotgun I bought in a fucking store to hunt fucking geese with, for Christ's sake.
Jesus.
Did you bring him a beer?
No, sir, you only wanted the one, I thought.
What?
You only wanted one drink, I thought.
I'm drinking his beer. I'm drinking a man's beer on him.
I
Get
want
him a
another
beer.
one. It's all right.
All right, don't have no more. So, yeah, Topper.
You're hitting that stuff pretty hard, aren't you, Mickey?
I can handle it. So Topper, yeah, Topper. He feels responsible, and, you know, he's an old guy. He hasn't been pitched about 30 years. So we figured the shotguns are going to be his. I'm just doing the old man a favor, driving him down there and all.
Yeah, but if they don't?
I do time. If the shotguns aren't his, I do time. It's that simple.
There's the statute, 2C39-7. It's part of the Graves Act. And when you have clients who are pleading out on things, especially if it's involving domestic violence, please, please, please make them aware of the certain person statute. I think even for disorderly persons offense on domestic violence, Chris, that you become a certain person. You're not allowed to possess these firearms. So please make sure your clients are aware of this, because sometimes offenses that have nothing to do with firearms at all put them under the net for certain persons. And they be doing something perfectly innocent, you know, going out, target shooting, skeet shooting, hunting, whatever it may be, and all of a sudden you got a big mess on your hands, okay? All right, we have to end with this. Could you think of a more perfect movie to end with? All right? This will give you an example. This is technically shoplifting, but we'll do it in the context of theft of movable property, 2C20-3. Let me know if you think this guy's guilty, all right? Take a look.
Otter, please.
What are you doing? I'm fixing your sweater. There you go. Now look, keep on me. Keep your sweater closed. Hey, I could get in trouble. That's right. So, be cool. Nothing for me today, thanks.
It looks like you gained some weight since you came in.
It's just a prank. I'm pledging a fraternity.
Don't sweat it, sweetie. I won't tell.
I'm sorry, guys. I just had to end with this. It's too funny. I can't tell you the number of times I've with clients. They'll say, "Well, I could go to jail for this," and I say to them, "That's right."